Just one moment, Miss Hannett. Yes, that's absolutely fine, because this is handed down and sent to you. It's handed down by being sent to you. Yes.
Before lunch, I was about to turn to ground 4. And
yes, I just wonder whether there'd been some confusion for which I was responsible. We're not expecting you to take us to all those documents. You just use the chronology as your guide to the extent you want to refer to things at all. But when you do, just give us the reference, the page reference in the bundle. And if we say, oh, we'd like to see that in the real document, we can then look at it. But don't feel obliged to take us through everything.
What I might do, having reflected on it over lunch, is that I've got quite a small number of documents to take the call to.
Do it your own way.
If I find that I'm taking longer than my allotted time, I will revert back to the chronology.
See how it goes. But I didn't want us to be the cause of unnecessary.
No, that's a very helpful indication. I'll try to do a sort of hybrid model.
Off we go.
So this is a straight rationality ground. We say that no reasonable social services authority could have concluded that DF did not require accommodation from the 2nd of January at the very least. And so that, of course, she had accommodation in fact, but the authorities show that the simple fact of having a roof over one's head doesn't necessarily lead to a conclusion about whether the child requires accommodation. There might be a variety of reasons why a child might require accommodation because of its, for example, because of its temporary or unsuitable nature. We say that has to be judged by reference to what was apparent to the local authority as at the 2nd of January. It mustn't be judged with the benefit of hindsight because, of course, that things worked out in the end is not the question of whether not doesn't help to understand whether or not the decision of the local authority as at the 2nd of January was rational. I'm going to show you. I was going to show you 2 authorities, but given the time, I'll show you one authority, Coventry. I'll just give you the paragraph references to a second Brent on the point of precariousness. Before doing so, I just want to go back to section 20 because Russell Underhill and I may recall that just before lunch, I think that you asked me about suitability.
Yes.
And I said that was to do with requiring accommodation, to do with precariousness. In fact, Madonna Junior has ever made a good point over the lunch German, but in fact suitability is referred to in section 20, subsection 1, that's subparagraph C, page 25, tab 5 of the bundle. And where the person who has been caring for the child prevented from providing a suitable accommodation or care. So in fact, sorry, I was wrong about that. There is in fact a direct reference to suitability within section 20 itself. So turning then to Coventry, that's tab 19. Just to locate this in the decisions of the House of Lords that I referred you to this morning. This is post-Hammersmith in the House of Lords, pre-Southwark in the House of Lords, but it's after the Court of Appeal's decision in Southwark. And the reason I just flagged that is that there are that the Court of Appeal in Southwark, the majority decision was overturned by the House of Lords in due course, and so the references in this case to Southwark are to the Court of Appeal decision. So the facts are paras 1 to 4 and 9 for your note, but very broadly, T, who was aged 15, was thrown out of his father's house and went to stay with a family friend, Ms. C. She took him in, looked after him. Some 4 months later told social services that absent financial assistance from the local authority, he would have to be taken into care. So he had accommodation, but that accommodation was uncertain in the sense that the person who was providing it said that she couldn't continue to do so without financial support. So the issue in the case was according to what arrangements, if any, or under what arrangements of any, T was being accommodated by Miss C. And then just pick out the relevant passages I made. Paragraph 26 on page 301. The local authority in this case was saying effectively it was a private fostering arrangement with which the local authority had no involvement. The judge, Sir Stuart, Queen's Counsel to the Deputy, considers section 17 of paragraph 26. And notes submission for counsel to the local authority that definition necessarily involves having regard to the future. And then he goes on to apply that conclusion to section 20. Must follow the suitability of accommodation for a child in need must also be adjudged, at least to some extent, by reference to something more than just its immediate condition. For example, I cannot see how accommodation with a family that was on the point of being evicted from its home could be regarded as suitable. In other words, it's not just the immediate physical fact of accommodation, one has to have some regard to its future suitability. Just to accommodate you, or just to contextualise what comes next, the respective arguments of counsel are in paragraph 28. Submission on behalf of T was that accommodation that's temporary and precarious is not suitable. And because Miss C couldn't continue to provide it, if she wasn't provided with financial support. There's then consideration of the authorities by the judge from 31 on all the way through to 59. It's quite a long passage. He picks the issues up at paragraph 60 on page 310. And sets out the issues in paragraph 60. What did the council do between the relevant dates about providing T with accommodation? And if the answer to that is nothing, I mean that's after T left his father's home, was the council decision a decision that was reasonably open to it, obviously required the application of a test of perversity. So he then goes on to consider issue 1, which we can skip over, that's 61 to 66, but the short answer was the council didn't do anything. Save or approach this on the basis that the accommodation was a private fostering arrangement. You can see that in paragraph 68. But the key part for our purposes is paragraph 74 on page 312. I can ask the court to read that.
Yep. Okay. Yep.
Just to know, I think I probably right to say that the reference to the resourceful person, certainly in the form of
Sorry, I can't hear what you're saying.
But the reference to a resourceful person in that paragraph, certainly in relation to a 15-year-old boy, probably does not survive the decision in Suffolk, and
Yeah.
that's why I flagged that at the outset. But the remainder of that paragraph in my submission remains good law. The other authority, I think I'd probably just give you the references to, because it makes the same points, is Brent, which is authority tab 33, starts at page 554, and the relevant paragraphs are 45, 46, Roman 1, 2, 4, 5 and 7. Again, that makes the same point that the accommodation has got to be suitable. In the sense of not being precarious or temporary. So just turning to the facts of our case then, we say that at the point the notice to quit expired, on the 2nd of January, the accommodation was precarious in at least 3 ways. First, she was present unlawfully. Second, Colchester had indicated that she would be evicted. and that was their consistent position from early November. I'll take you to the document in a moment. And there was uncertainty at the material time, rather than with hindsight, as to how long that process of eviction would take. And so just deal with the material in three ways. First of all, what Colchester said or did. Second, what Essex was saying at the relevant time in its own documentation. And then I'm just going to indicate those parts of our skeleton where we set out all those places where it's apparent that DF indicated she had a need for support. So just dealing with what CBH said or did, I'm going to show you the original documents if I may, and if I find I'm taking too long, I will revert back to the chronology. And what I'm going to do is I'm just going to follow our skeleton argument at paragraph 20 and just take you to the documents that are set out there. And the first is communication from Colchester Borough Housing on the 9th of November, and that's in the hearing bundle below at page 276. It's over 2 pages. Confirms in the second paragraph that the succession application was refused. Fourth paragraph, I've submitted your written request for succession application has not been successful.
Say 276. Oh yes, I've got it. Sorry. Yes, thank you.
2 paragraphs down, housing will be made, so they will be making a referral to Essex County Council. And then bottom paragraph, finally, you say if you're not able to succeed to the tenancy, you would move to your partner's mum's house and return possession of the property to us. You make an application for housing in your own right once you reach 18. Over the page, this appears to be the I think what's above that is the message that he, i.e. Rob from Colchester, sent to DF, and then underneath the words "yours sincerely" on page 277.
I'm clear what it is. Yeah.
Again, repeats the question about asking if social services will be able to help with housing if she decided not to move to her partner mother's house. 2 paragraphs down from that, CBH would be grateful for, and that's DF, to make a decision. Currently, tenancy has large arrears. We're at the stage we may need to legally ask the premises back. And then again, the final paragraph, repeat the reference to serving some legal paperwork to end previous tenancy of premises are not to be surrendered voluntarily.
Yeah.
So quite clear from that they want the premises back. The next document is at page 200 and so sorry, I can't get the reference across one. Just bear with me 1 second. Sorry, just bear with me 1 moment. I've gone one ahead of myself. I meant to take, I'm so sorry, to the actual entry for the 9th of November, which is on page 264. This is a little earlier in time. It's a telephone call with Mr. Ward from Colchester. It says, first paragraph, can't accept her application for succession. Next paragraph immediately underneath, doesn't have a duty to be housed by Colchester. Again, referral, notes that housing has made a referral to social care because he was concerned by DF's presentation, and sets out the details of that. DF had told him that she has made no claim to benefits, got no income coming in. Notes that when she's 18 they will have a duty to house her, but it could be temporary accommodation. Colchester Borough Homes have just noticed there are rent arrears. Needs to move, that very last point on that page, she would need to move out. And then this is the point where Lady Justice King this morning, I said that Colchester had suggested that she remain where she was, but that social care paid for it. If social services were to take her under their wing as a minor, we agreed to pay rent for her to remain where she is. And in 7 to 10 days, get 28 days notice to leave. So again, quite clear at this point that Colchester want the property back, to put it colloquially. Sorry, I've gone. That was the 9th, the 11th, and the first document I took you to was the 11th. So I've gone slightly out of kilter. On the 16th of November, that's page 278. This is a telephone exchange between the social worker, Lauren Pinchas, and somebody at DWP about whether or not DF can be provided with universal credit. At the bottom of page 278, underneath the last Lauren Pinchas senior practitioner heading, so she's living alone in property, doesn't have rights, and they plan to evict her. We were told she does not have succession rights. And then, so again, quite clear that the council was under no illusions that she was going to be evicted. On the 2nd of December, page 310.
310.
There is a phone call between social care and the claimant in respect of closure of her case to a young carers service. And the claimant explains it's the final substantive paragraph on page 310 about what was said to her when the notice to quit was dropped around. Explained to her that she would need to be out by the date of the eviction notice. If she was still stuck anywhere to live by that time, it would take a few weeks before it could go to court for her to be removed from the property if she did not move out by the date on the eviction notice. So again, the notice to quit was served. No suggestion that anything other than Colchester would move to enforce. Over the page at 312, this is a case note for the 6th of December. Sorry, I should say it's a conversation between the local authority and Forum Voice, who I understand to be DF's advocate at that point. And about halfway down it says delivered eviction notice, probably delay in the court, so maybe okay until April, but not certain. So, and then the final two references, page 325, which is, sorry, it's a record of a visit. The record starts on page 323. It's a record of a visit dated the 7th of December, so it's after the notice to quit has been served. And on page 325, bottom of the page,
You got the point. Yeah, maybe able to remain till March.
yeah, but also they're going to approach housing. And then finally, the final point is an email of the 8th of February, which is page 391. Email from Colchester setting out its position as of the 8th of February.
We've left the guidance of your skeleton now, have we? Always just.
Yes, that's one extra. You're quite right, Michael. That's one extra. That's a
fine.
bonus point, if you like, beyond that in the skeleton. But the point is, simple point is, that it's only with the benefit of hindsight, it can be said on the 2nd of January that she would be permitted to stay in the accommodation, and that position, certainly as far as Colchester was concerned, as of the 2nd of January, was that it intended to obtain possession of its property.
But only by going to court after the expiry of the notice to quit.
Yes, so after the 2nd of January, I accept that. But when one goes back to the notion of whether or not accommodation is suitable, by dint of, for example, its precarious nature, on any view, the length of time by which she could remain at that property was uncertain. Of course, she had a roof over her head, but as I've indicated, she was there unlawfully. They said they were going to evict her, and it really was uncertain at that point how long it was going to take.
It was 2 months before her 18th birthday.
Yeah, exactly. So that's the position of Colchester. Just briefly in terms of the position of Essex, what I might do is just, with 1 eye on the time, go back to the chronology, if I may, and give you just the page numbers. And in particular, really just to show you the...
Remind me where the chronology is.
It's in the core bundle, my lord, and it's at page 32. And the particular points that I want to take you to are the children and family assessment. So the point is this, really, that Essex conducted a children and family assessment, and they also conducted a child in need plan. And in both of those documents, they accept that her homelessness, also her housing, is precarious, and that steps will need to be taken in order to provide her with accommodation. And that's really the point. Now, just the children and need plan is in the chronology on the children and family assessment is in the chronology for the 30th of November, page 39. The reference in the bundle, the hearing bundle below, is page 290.
Thank you.
And you can see in the chronology on page 39, the first substantive paragraph, her DF's main concern is her housing situation. Wants to remain living with her boyfriend, have care of her cats. She understands that she cannot remain in the property and there will be an eviction. Options are being explored with housing and family for DF's accommodation. And she'll require the supportive services to ensure her housing and financial needs are met. The outcome, the very last phrase on that paragraph is that the outcome for housing needs are currently unknown. And then over the page on page 40, there's a discussion at the time of producing the assessment. It's the second box on page 40, where the discussion between social workers about what options are available for DF in regards to accommodation once she receives an eviction notice. Now,
What's the document reference for this?
this is a discussion in the children and family assessment. It's
Yes, but there's a page reference in the bundle. I thought you kindly marked it up.
I'll ask my junior to
carry on.
pull it out.
307.
307, I'm told.
Thank you.
And just to locate this in time, this is the 30th of November. The very next day, she receives the notice to quit. And then in the paragraph immediately after, discusses that she's going to be given a child in need plan, even though they don't normally do that for 17-year-olds. And then the very last sentence of that first paragraph, social care are unable to support the source of accommodation because there are family members that DF could live with if she were to take up the offer of support with rebuilding the relationships. Of course, that's a reference to the dad, and that in due course, if it ever was an appropriate suggestion, was accepted not to be a suitable suggestion. Then there is the child in need plan, which is the 7th of December on page 41. That is in the hearing bundle at page 317. And in respect of...
So what's the date in the chronology?
7th of December, version page 41.
Yes, I see. Thank you.
The format, what are we worried about? The worry is a risk of homelessness. what needs to happen, that DF will explore housing with her partner, how things will get better, DF will have, say, stable housing. So, in other words, at this point in time, the local authority are accepting that the accommodation is unstable and that steps will need to be taken to resolve that uncertainty. And this is now the 7th of December, so after the notice to quit has been served. There's then, we set out in our skeleton argument at paragraphs 25b a number of examples from the paperwork of where it might be said that DF required the kind of support would be offered by section 20, inability effectively to look after herself.
Where's that?
It's those matters that we set out in paragraph 25b and on. There's a long list of them.
25B.
Yes, it's
On
page 10
pages-
to 11 of our skeleton
Yes, I
argument.
see, thank you.
I don't propose to go through all of them, but they include the fact that the local authority knew that she had no income, that she was living off food parcels and the odd tenner, the house was not secure, and that she was using cannabis to such an extent that she was selling off her possessions to fund a debt to her dealer. So, just bringing that to a head then, the notice to quit expired on the 2nd of January. We say it's apparent at that point that the duty had arisen, and in fact there is a meeting between DF and social care on the 4th of January. And can I just show you that in the hearing bundle? It's at page 331. So it starts at page 331 on the 4th of January, and it takes place in the social worker's car, as you can see from 331. On 332, but the reason it took place in the car is apparent from the first paragraph. DF told the social worker that she couldn't come in as she's sorting things out for the move. She then explains on page 333, second and third paragraph, that she doesn't want to live with her father. There is then at the bottom of that page, bottom of 333, that she has little money. She then says that she's honest with the social workers. The reason that the social worker couldn't come in because that she's selling everything to pay the debt off. That's the cannabis debt. 2 paragraphs down, the social worker asks DF about the message she sent, i.e. the social worker, asking for help with housing appointments. DF says that she hasn't got any booked, but she would appreciate support in attending housing and making an appointment. And so that can be looked at with a social worker. So this is the point at which we say the duty has arisen. There's no discussion here about whether or not DF wants section 20 support. But what DF is making quite clear is that she does require support with her housing, and indeed is asking for that. So we say, as of this date, the duty had arisen, and we say it was irrational for the local authority to conclude otherwise, and an error of law for the judge to reach the finding that he did.
And you say, in effect, that nothing that happens after the 4th or 7th of January can affect that.
Exactly.
Even if she's offered, she was offered alternative accommodation by Colchester on the 17th of Feb. But you say that's too late.
Well, it's too late, but it's also the reason she was offered accommodation by Colchester, as Colchester explained, was because they were concerned that Essex hadn't accepted that they had a duty to her. That's set out in the chronology. So it is true.
That's the chronology.
Let me just find the reference page. I'm so sorry. It's page 45 reference for the 17th of February, and it's the third substantive paragraph down. It's a witness statement reporting the reason that was given to my instructing solicitor as to the basis on which the duty had been offered by Colchester, which was an exceptional duty. They said it was an exceptional duty. So, yes, of course, in this case, happily, DF was housed. But it's quite clear that that is only, one only gets to that with looking at the benefit of hindsight. And that we say that the critical question is, was it rational on the 2nd of January for the local authority not to find that a duty arose in respect of DF? We say no for all those reasons. I'm overstraying my time. There were 2 points that were raised this morning I said I would come back on. First was a question about whether we had been refused permission below.
I was wrong about that. I was confused about the grounds on which you refused permission here.
It was only we were in fact granted permission on everything below.
Yeah, I saw. That's why I said I was wrong.
Oh, I'm so sorry. I thought I was wrong. And then the question was about whether or not you need a court order to evict a residential occupier.
Yes.
We say you don't, and that was the finding of the judge below, para 66, and that's because section 3 of the Protection from Eviction Act only applies to protect you from eviction without a court order where you have a lawful occupation of the land. And because she didn't have a lawful occupation of the land, the Protection from Eviction Act didn't apply, and that was quite a lot of...
Anyway, but that's fine. The judge has found that. There's no respondent's notice saying he's wrong.
No,
So we were just exploring it. It's very helpful.
May I have 1 moment?
Of course.
Something wrong.
Right?
That's something wrong. And there's something called accelerated possession proceedings. I don't know much about it. It used to, when I was a young barrister, it was Order 113 of the old White Book. It's now CPR 55 something. You can't just send in the heavies to drag people out onto the street. You have to make an application to the court. It's not as elaborate as if somebody has a tenancy. I don't think I'm making this up.
Well, Mr. Orban may be able to tell us the answer. The two of you can think about it, and if he can't, or those behind him, we'll have to do it for ourselves.
My Lord Junior, who does know rather more about these matters than I do, and I'm afraid everything that they say on the subject
Probably
is
more than
coming
I
from
do.
him, assures me that is correct, and it certainly was the position that the case on the basis
Well,
on which the
the
case
formal position is the judge found that there was no protection for eviction, but everyone was, on the other hand, that's more importantly, everyone was proceeding on the assumption that that Colchester would go to court. So it may not matter.
Yeah, I accept that. I accept there's a dispute about the timing and the certainty and all the rest of it, but certainly that, whether they were right or wrong, that was certainly the approach they took in this case.
Okay.
So
Thank you.
I'm also better can help with anything further. Those are the submissions on behalf
As
of the
far
defendant.
as any of us are concerned. Thank you. Yes, Mr. Orban.
Wonderful lady. I will go through grounds 1 to 4 in numerical order. Ground 1, our overall position is that section 175 and section 20 involve different concepts, and if Parliament had intended them to be formally linked in the manner suggested by the appellant, then it would have said so. That's our number 1 point, and I think that is a complete answer. Parliament has chosen not to link those 2 concepts. It could have easily done so by a simple cross-reference. That would have made that clear. It hasn't done so, and we suggest that's really
that's a good, straightforward point. It doesn't require much elaboration.
And then next, I would like to touch on some particular legal points arising from 4 sources: section 20 itself, secondly, the 2002 order, thirdly, guidance, and fourth, G and Southwark, to the extent it assists. On the first point of section 20, I'll just list the points. I'm not going to elaborate from our skeleton, which is the difference in the wording and content of section 175 and section 20.
Just give us which paragraph of your selection are you referring?
39.
39, okay.
The first point is that section 175 is cast, at least in part, significant part, in terms of legal rights
Yep,
rather than factual circumstances. Not in totality, but certainly in significant part.
yep,
And that involves investigation and examination of legal concepts, which section 20 doesn't require. And we think it would be quite concerning if social workers are driven down that path.
yep,
We've made the point that section 20 applies if it appears, which is consistent with it being a factual analysis. And thirdly, the point that they are directed at different decision makers. In particular, section 20 is cast upon by social workers. And that leads us to the next point, which we make at the skeleton paragraph 42, which is it's unlikely that it was Parliament's intention to have intended that social workers on the ground would have to apply technical legal concepts, or rather a formulation that in part turns on technical legal issues. It's much more likely that they were directed to apply a broader factual analysis that isn't so dependent. And an illustration of that we've got from our discussion this morning, because there was an examination of, there was another provision helpfully brought to our attention by the appellant about legal estates, children not being able to hold legal estates. And as has been noted, well, of course, there are other things apart from legal estates, such as contractual licenses or indeed equitable interests. So are we really directing in section 20, if it's linked or pulls in section 175, are we really directing social workers on the ground to determine whether a child holds an equitable interest, such that section 175 has a particular outcome and therefore section 20 has a particular outcome? Are we really expecting social workers to stop and answer what may be a complex legal question, which took up some amount of debate amongst all the esteemed legal minds in this room? In some cases, indeed, this may have been one of them. There is a degree of legal analysis and debate around that that is really not the business of social workers determining a more broad-based factual question of whether a young person requires accommodation. It would be wrong to import those concepts into it. It would be wholly unuseful, and Parliament could not have intended it. We've also made the point that the outcome is a common sense and logical one. That's our skeleton paragraph 43, which you can read and I won't repeat. I will, though, just answer one question. It was said in response to what we had in our skeleton that, for example, a young person who is sleeping on a sofa for a night or more than one night, that they would be homeless because it's not reasonable for them to continue that occupancy. Well, they may well be homeless. They may well be not. If it's the night before their 18th birthday, there are innumerable factual scenarios, and one shouldn't prejudge or impose rigid rules on what is a broad-based factual question. And thirdly, I don't think Southwark, or the sentence in Southwark that references sofa surfing, was intended to be a hard-pressed rule. It might be an expectation that in most cases, but the overall point is we don't know. It's a factual question, and section 20
for the
should
present
stay
case
as a
is
factual
the
question.
case of sofa surfing anyway.
Yes. To answer a query that came up before the short adjournment, section 20, when does the duty crystallise? I think this is a point that Lady Justice King asked. The answer is to look at section 20. I don't mean to be unhelpful by that, but we do have to keep in mind the exact wording, because it makes a difference. It's in the authorities bundle, pages 25-26. first point on this is that section 20, right through, it's very clear. What is it a duty of? It's a duty to provide accommodation. Start with the heading, then subsection 1, every local authority shall provide accommodation. And right through subsection 3, every local authority shall provide accommodation. Blah, subsection 4, may provide accommodation. And we get to subsection 6, which was touched upon before providing accommodation. So section 20 is a duty to do a thing, X. That thing X is providing accommodation. Subsection 6 says before X, before the thing.
Yeah.
Before that thing, the local authority shall, as far as reasonably practicable, and consistent with the child's welfare, ascertain wishes and feelings, and give due consideration according to their age and understanding. Now, obviously, you've got well in mind there's a point about a 17-and-a-half-year-old at the upper end of childhood towards adulthood. So the answer to Mady's question, when does the duty crystallise? The duty to provide accommodation, the duty crystallises at the point that it appears the young person may require accommodation and is therefore subject to the duty. And that's subject to subsection 6. So subsection 6, before that thing is done, before that duty, the local authority must ascertain wishes and feelings.
So what you say is it's before the duty bites,
Yes.
as opposed to it being a conditional duty.
Yes, it must be.
You use the word crystallises, I mean, yeah, it's the same concept, yeah.
Yeah, I'm not getting hung up on the terminology, but before...
But the basic point is that the nature of section 20 is such that there is built in a time frame between, if you like, the issue first arising and the actual duty to something occurring.
Yes.
How long that is, no doubt you would say, will depend on the circumstances.
Yes.
It might be very short, but
Yes.
it might, in a case like this, be a bit longer.
Yes, and that's encapsulated in the first word of subsection 6,
Yeah,
the before.
okay.
And the sort of thing it depends on is the sort of thing I was looking at in B, is when they become a looked after child.
Yes.
So it's all sorts of things that
Yes,
that
it
mesh
can be
together.
a vast range. And in this case, what's striking about our case, and we have to be very sensitive to the specific facts, is that there was a lot of effort gone to, a lot of the social workers' notes and time and reference is about subsection 6. It's about trying to ascertain which things, and that's particularly important given the age and level of understanding. We're not talking about a 14-year-old. We're not talking about a almost 18-year-old with very little mental understanding. I'm sure you've had other cases that are very different in nature of young people with very limited cognitive ability. This is not this case. You've got a 17-and-a-half-year-old, a 17-3/4-year-old with a good level of understanding, able to articulate her wishes and feelings, and she had them, and they're also entirely understandable ones.
She was going to, and I haven't obviously read the whole of this case file, but just from the helpful pointers we've had. So, you know, first of all, she was thinking, well, I can stay here, no, I can't stay here. I can go with my dad, no, I don't want anyone to help me get back with my dad. It actually is a duty of the local authority to help people to build relationships. And she was offered that and she said, no, I don't want that. Then she thought she'd live with her boyfriend's mum, and that wasn't going to work out. Then she thought he might get a tenancy, and that wouldn't work out. So she was going through all sorts, as a nearly 18-year-old, all sorts of potential solutions.
Yes.
Medium term for her, but it certainly weren't, well, I'll go into foster care,
Yes.
or I'll go to a residential unit, because
And-
therein I will not have my boyfriend.
Yes, and all the things she's articulating are not unsensible, it's not a very good word, but she was articulating perfectly reasonable thoughts and wishes and feelings. My boyfriend's important to me. She's just lost her mother. It's quite a priority to live with him. our cats are important to me. One injects our love into our pets. That's a perfectly rational thing. That's important to her. And it was never a set, fixed point. And it's an unusual case, but this is a case in which we're within that first word of subsection 6, the before. But that's what the local authority is trying to determine, because it matters. It matters what she wants, and it matters to whether she requires section 20 accommodation.
If you're talking about duties, would you say that there's a duty under 20 subsection 6 to start by ascertaining the wishes, and then when you've ascertained the wishes, there may be a duty to provide accommodation?
Yes. Yes, and subsection 6 is a shall as well. Before
Yes.
X doing that thing, before shall, as far as practicable. And this is a case in which it was practicable. It was a very good idea. She's almost an adult herself. She's got a good level of understanding. She's got very...
We have the point.
Thank
Yep.
you. If I can just have one sentence more on that. My point is, the degree of weight one places on this subsection 6 point does vary according to age and understanding, and we're a high end of that here.
Yeah, I've got that point.
Another point on, the final point I wish to make on section 20 before I move off it is, before the show adjournment, the appellant was asked if accommodation, as section 20 accommodation, could be where she was currently living in that flat. The local authority at the time had a view on that. They didn't think it could be, or should be, and they gave options that were not that, other options, and explained why living with a boyfriend in that flat wasn't one of the options. That became ground 6 in this court, challenge to that, and permission was refused. So there's no debate anymore in this court on that. I think where that leaves us is it's beyond legal argument in this court that the section 20 options at the relevant time did not include the very thing the appellant most wanted.
Sorry, the appellant.
The section 20 option at the relevant time.
Yeah,
Section 20
so
option
I just
did not
didn't hear
include
what
the
you
very
said.
thing the appellant most wanted.
I still didn't hear it, so we're talking everyone. The section 20 options did not include.
The very thing that the appellant most wanted.
Thank you.
That's relevant to looking at subsection 6, which in turn goes to the word before, and therefore when the duty crystallised. That's section 20. I hope I'm not counting through too quickly. The next source of law I want you to take you to is the 2002 order. And I think this is useful to us, and I'll give you the headline, the spoiler. The point of it is, it was referenced in the skeleton, but quite briefly, but I want to spend a little bit of time on it. The 2002 order shows that some homeless children are not owed a section 20 duty. And we think that's consistent with our case and less easy to reconcile with the respondent's case. To make good that point, I need to explain 3 matters. 1, the criteria for the Housing Act duty to accommodate the homeless includes, as criteria, both homelessness and priority need. Priority need is one of the criteria for the Housing Act duty to homeless. The second point is the statutory concept of priority need is only relevant to consideration of homeless people. Doesn't serve any other function. And thirdly, taking those two together, I will show you them and explain. The third point is, this shows the 2002 order only has meaning in relation to 16 and 17-year-olds who are homeless and who are not Section 20.
Can we say that again?
The 2002 order, the particular provision we'll look at, only has meaning in relation to 16 and 17-year-olds who are homeless but who are not within Section 20. And it's worth bearing in mind when looking at the appellant's argument, the two must necessarily be linked. A decision on 175 must follow through to a decision on Section 20. I'll briefly explain each of those three propositions, if I may. The first one, the criteria of the Housing Act duty to accommodate the homeless includes priority need. So I'm going to ask you to go to the Authorities Bundle, tab 6, page 56. This may be page 55. This may be old hat, so my apologies. It's all very well known.
Go through it fairly quickly, and if we don't understand, we'll slow you down.
Thank you. 55, interim duty. These are core duties of the Housing Act. Bundle, Authorities Bundle 55, section 188(1).
Yep.
If local housing authority have reason to believe an appellant may be homeless, that's one criteria. 2, eligible to the second criteria. And 3, has priority need.
Yep.
So priority need is a criteria. You also see it in the next provisions below 1ZA, priority needs mentioned as well.
Okay.
And you also see that on Authorities Bundle, page 60, section 193, which is the main duty. And you'll see duty to persons with priority need who are not homeless intentionally. The section applies and you see the criteria. And you can see B, 1D, satisfy their priority need.
Yep.
And the duty there follows subsection 2, unless the authority refers the applicant to another housing authority, they shall secure accommodations available for accommodation. So priority need is one of the criteria.
Yeah. So you've made good your point 1.
Yeah. The second point is the statutory Housing Act concept of priority need is only relevant to consideration of homelessness. It doesn't have other, it's not the free floating application. So if you're talking about a person that has priority need, you're necessarily talking about a person who
Yeah,
may be
I
homeless.
got the point. I'm sure.
The third point is that the 2002 order only has meaning when you're looking at a 16, 17-year-old who are homeless but not Section 20. And for that, we need to go to the order, which is at tab 7. You can see on the first page of tab 7, it says what happens with it. Basically, it's a list. 2 says descriptions of the person specified in the articles have priority need. So everything listed is priority need. It's a list. The first point on the list is children aged 16 or 17. And what this list item is on Article 3 is essentially a person who is 16 or 17 is not subject to Section 20 duty. And you can see that in the first parenthesis, a person brackets other than a person who in paragraph 2 below applies, and paragraph 2 is Section 20.
Yeah.
So this person who is not Section 20 is in the list of people who may be priority need.
So it recognises the possibility of a class of people who are between 16 and 17 with priority need, but aren't. Are between 16 and 17, but aren't covered by Section 20. That's your point.
And priority need, therefore, under the homelessness regime. And the point is, that's difficult to reconcile with the appellant's argument that if you're homeless under the homelessness regime,
Yeah.
it automatically follows through
We
this.
have the point.
We'd say that that article would, at best, be OTOs, or at worst, nonsensical, if the appellant's right.
Yeah.
The next source of law is, well, next source I rely on, is the guidance. That the appellant relies on that to advance their case, that the two provisions are linked. And if I can just get that up, tab 11, prevention of homelessness, etc. guidance. My authority bundle page 100 is paragraph 3.2, and we note the point made by Lady Justice King that 3.2 contains, well, my words, not yours, but gradations of homelessness. Immediate threat, imminent, actual gradations. And we say that shows the approach to 16, 17-year-olds is actually very fact-sensitive and not a technical one. It's different to the appellant's case that you're within a Housing Act definition, therefore you're within Section 20. Authority bundle page 105, paragraph 3.28. Where a young person seeks help because of homelessness, so piloting a homeless young person, then there's assessment to reach a decision on whether or not they're in need and requires accommodation as a result set out in Section 20. So they're homeless, so assess whether they require accommodation. It doesn't say they're homeless and therefore they necessarily are requiring accommodation. It's saying the opposite, actually. It's completely inconsistent with the appellant's position. In fact, it says the reverse. Authorities, page 114. Paragraph 4.8. Where Children's Services have decided, obviously our case isn't a decision on Section 20, for reasons the authorities obviously made them deciding that. Where Children's Services have decided a Section 20 duty is not owed, or the young person does not wish to be accommodated, housing services duties under Part 7 will continue. So, not Section 20, but maybe homeless. Because they explicitly say that the housing Act duties may apply. So you can be homeless, but not Section 20, according to that paragraph. Again, inconsistent with the appellant's case. So the guidance expressly contemplates this very situation of not being within Section 20, but being homeless. At least it's consistent with our construction. That's the guidance. The next source, final source, on this is Southwark, and I can take that briefly. The spoiler is we say Southwark is actually consistent with what I've just been saying. It's reflective of and consistent with this analysis. And the reading of the 2002 order, which I just took you to, Southwark reinforces that reading. It's the Authority Bundle 317. Pardon, I don't need to take you to that anymore. Paragraph 26, which is on 3.2, Authorities page 322. You were taking this paragraph, but it was slightly skimmed over. I don't want to dwell on it for a minute. Page 322, paragraph 26. And we say this first sentence, you've got to pick up the first and second sentences because they are quite different in what they're doing. The first sentence, can you see it is true? It is true, as Mr. Maguire, as the local authority points out, 2002 order assumes there will be some homeless 16, 17-year-olds who are not owed a duty. Now, that's the very thing I was showing you. 16 and 17-year-olds are homeless, so tick the 175 box, yes, but not Section 20. Now, that could be either the opening words of requires accommodation, or it could be the following because none of the ABC apply. But it certainly postulates there's a world in which you can be 175 homeless, but not Section 20. So it's not such a surprising or bizarre conclusion to reach, indeed contemplated by Southwark. Now, the different thing that follows in the next sentence, why you need to separate out these two. It's quite important to separate out these two sentences, as indeed it says it's a very different thing. Baroness Hale's making a separate point. It's a different thing from saying there are children who are not owed a duty under Section 20 because they are, or may be owed a duty under the 1996 Act. The because is important. You shouldn't reason that because of a conclusion on housing, therefore they're not owed a duty under Section 20. It's that's the wrong reasoning. It's the because that's wrong, or that one shouldn't do. And it's that what Baroness Hale is describing as circular reasoning. It's the correct approach to avoid circular reasoning is to do actually what we said the local authority did here, which is to determine whether Section 20 applies. That's the correct approach. Treat them as separate systems, decide whether Section 20 applies, yes or no. If it doesn't, well, in that, then there may be a different issue under the Housing Act. But you don't link the two. And that makes sense under the 2002 order. Because if you go back, I'm not suggesting you turn it back up, but to cover it briefly, if Section 20 applies to the 2002 order, that subparagraph 2 applies. If Section 20 applies, Article 3(2) applies. And that means Article 3(1) doesn't apply. So 16 and 17-year-old who is within Section 20 is not priority need. Housing Act duties don't apply, but there's Section 20. That makes sense. If Section 20 does not apply, or it hasn't been decided that it does apply, then under the 2002 order, Article 3(2) doesn't apply. That subparagraph isn't met. So Article 3(1) may apply. So the order works and makes sense that a 16 and 17-year-old who is not within Section 20 may well be priority need and the housing duties may apply to them.
So does that tie in then with what we see in the guidance at 3.62 and onwards about the local authority's duty to refer to housing services?
I'm tempted to just say yes, but I haven't got the paragraph in front of me. But
Jumped ahead.
it sounds right. It sounds right. I probably should bring it up before I commit to something.
Not sure which paragraphs my lady referred to.
3.62.
Page 111.
Thank you very much. Yes. Yes, then a local authority children's services among local authorities is required to notify housing authority. Yeah, so that fits with the operation I've described.
You see, but 3.63 deals with 16 and 17-year-olds.
Yes. And deals with the issue of consent.
I'm happy to be corrected because I'm not, completely familiar with all of this guidance, but answering through it, it seems to me that it may be relevant.
Yes. And the issue of consent. And it partly also explains, I mean, I'm not suggesting that the social worker was looking at 3.63 at the time, but it's consistent with the approach of social work, which is to spend quite a lot of time on what DF wanted.
What sorry?
What
DF wanted, yes. Sorry.
their wishes, feelings, which is a statutorily mandated requirement, or to put another way, consent. It's also why are we saying this about 16, 17-year-olds in particular? It's because of their age. Because of their age, we treat them differently. You're less mandatory about them, if I can put it that way. You're as directive as to where you say they'll go.
Yeah.
So the point of all this is a young person you have to look at both tests in the right way, in the right order. You don't decide on housing and then follow through for Section 20. You start by deciding whether they meet Section 20, whether they require accommodation, and from that you might do things under the Housing Act, as we see here in the guidance. That's the correct approach. It's almost the opposite to the approach that's suggested on the other side. And finally, on Section 20, and this is anything I've missed all the explanation, but passing. Because I understand the concern, and it's quite right that there is a concern that local authorities should not be doing this. Should not be trying to offload or absolve themselves of statutory responsibility of people to whom statutory responsibility should rightly be placed on them, if I can put that as a legal summary of buck passing. And that concern is expressed in many places, including in G, and you've seen it. Now, our case is not that. It's not about buck passing at all. Our case is about Essex exercising its own Children Act functions based on DS circumstances. They were making decisions about DS circumstances. They were doing the very thing that subsection 6 says to do. They were looking very closely at what she wanted and what she wished for her housing. And it was the social worker's evaluation of her circumstances at the time. And that's correct and how it should be. And finally on that, section 20 is expressed in the present tense. Does she require accommodation now at this time? She expressed a preference for wanting to be in where she was in her flat. It clearly had an emotional connection to her, and there were perfectly obvious reasons for it, despite the drawbacks of it. And there wasn't a section 20 option open that involved living with her boyfriend and cats, and that was highly material to what she required. The final part of my submissions on ground 1 involved going through points made against us. I think that is really largely covered in the skeleton. So I can leave you, I think, with our skeleton paragraph 45 onwards, which goes through seriatim each of the points made against us. That it's lesser protection, that Section 20 is enacted in the context of the Housing Act definition, or homeless definition, and so on. There is a theme within the points made against us in the appellant skeleton, paragraph 12, about passing and about the schemes should work together. I would simply repeat the same point, that you start by looking at section 20 and whether it's met. Whether on the facts, and the facts of circumstances, someone requires accommodation. That's got to be the focus, and that was the focus. That's why it's not offloading responsibilities. There was one point made in my friend skeleton at 12C for Charlie, which is that there's a cooperation duty so the schemes are interlinked. Well, we've made the point that it's not unusual for public authorities, public duties to have a cooperation duty for perfectly obvious reasons. But in fact, this point goes for us, because if it's the case that it's right that housing and social services cooperate, and we know that's right, this is perfectly obvious. Well, if Appellant intended them to be actually linked, it goes back to my original point, and we've said so. I won't go through the remaining points. On the final point you make on the prevention of homelessness guidance, we make a point that guidance is persuasive only, and we cite a case, Chief Constable of Conbury and Wright. I don't think I need to take you through it. You've got the references if you want to follow that up. So that, unless there's anything that I haven't been sufficiently clear on, is ground one.
No, thank you. I think that's very clear.
If I can just leave them in my bag. I then want to spend a little bit of time on our, what we call our overview, the beginning of our grounds 2 to 4 section, a few minutes, because I think it is relevant, even if it ends up being a shade of obiter and a judgment. Any statement of the Court of Appeal in this area, the way the Court of Appeal looks at things like the social worker's work, the way it marks social worker's homework, does get read and reread, and it's quite important, which is why I wanted to say some things to make sure, to make sure there isn't, well, to try to fend off anything being said that we think is not right, and to direct to what we think is the right approach. So I make 3 points on the correct approach to analysing this type of decision making. The first is as to the nature of the decision making under challenge, which is relevant. The second is judicial review claims evaluating social workers' decision making, the approach that courts tell us to adopt in that circumstance. And thirdly, the approach of an appellate court to first instance fact finding, which I'll probably just give you the references to, I imagine. The first point, the nature of the decision making under challenge. This, and I think it will be sufficient largely to leave you with our skeleton. It's covered in our skeleton, paragraph 12. About it being a matter of judgment, evaluative questions. And paragraph 14 as well, that one shouldn't see section 20 as a straitjacket in terms of the choice of accommodation. Now, the reason we raise this point is that the appellant is seeking to impose on this form of decision making a sort of neatly bounded formality. As of this date, section 20 was triggered by the notice to quit. Notice to quit had legal effect. Those legal consequences meant this happened, and the social worker didn't fully recognise that, so therefore there was a legal consequence. That, we say, doesn't fit with the language of section 20. It also doesn't fit with the nature of a social worker's decisions on this, which are highly nuanced and fact sensitive. The other problem is it proceeds on the basis that social worker had reached a concluded view on the section 20 issue at that point, and she clearly hadn't. If we get to it, I can take you to the chronology references, which show around that time and after that time, there were discussions about perfectly valid options at different times, including attempts to see whether there could be reconciliation with the father, boyfriend's family, and other matters. Now, as we know, these things came in and out of, came in and out of being good or credible options. But the point was that in that period, around and after the notice to quit, the social worker was engaging intensively on that issue of accommodation options. It was a complex decision. DF was undecided as to what she wanted to do, and then Colchester made an offer, which resolved matters. So that's why in this first point we make so that this decision making is dynamic, iterative, and intensely personal, and it's ill suited to the kind of formalistic analysis that is sought to be imposed on it. A rather technical legal definition in section 175 is met, therefore outcome. It's completely ill suited to what section 20 is. The second point is the court's approach to decision making of social workers, and
Sorry,
say
I thought that was the first point.
I beg your pardon. The first point was the nature of decision making. Is
Yes, I
value
see.
to is iterative and dynamic.
Okay.
The second point is the court's approach
I see.
to social work decision making. And you can see in the case law a strong judicial emphasis on substance over form and the avoidance of formalism. Social workers aren't writing legal judgments or opinions. We're not expecting them to consult lawyers when they make decisions all the time. It's important that you evaluate their actions in a more broad-based manner and don't scrutinise in a technical way whether they decided on a particular legal trigger, a particular trigger such as whether there was a licence or so on. That, we say, is consistent with the Child case, which is in the bundle. I'm not planning on taking you to. We've got the reference in our skeleton,
You,
but the
you
broad
cited at paragraph 50 and
Yes.
we followed it in Davy.
Yes.
And it's pretty well established, isn't it?
Yes. So that was where this point is going. It's also relevant to bear in mind when you consider ground 2, the guidance ground, which is the point I'm going to come to if time permits. Cases such as, looking at cases such as Katoon and Tower Hamlets, it's important to avoid imposing on social workers a requirement for careful contemporaneous reasons for a departure from guidance. If they in fact acted, if they in fact did have valid reasons for the guidance, in an objective sense, that should be enough for the evaluation. I'll come back to that in ground 2. That's consistent with not approaching their task in a formalistic manner. And the third point to make on the overview is the appellate's court approach to first instance fact finding, which I think I've got to be careful not to say things that are too obvious to the Court of Appeal, but we've cited SMEC, paragraphs 27 to 29, which I can read to you, but it may not be necessary, about the appellate court's approach to findings of fact. What we do make on it is it's not just about findings
So
of
which
fact.
case is this? I mean, it sounds like it's all very familiar stuff, but if you are referring to it, you say 20, paragraph 27,
Page 27, 29,
Paragraph.
paragraph. Yeah, I'm sorry.
paragraph 27, 27, 9 of what? Of your skeleton argument?
I beg your pardon. Of SMEC,
Well, what?
which is.
Smedic.
Sorry, I'll start. I'm going too quickly.
Start again.
I'm going too quickly. My apologies. Tab 27.
Oh, I see, sorry.
I just thought you were going to take us to Bolby.
Yes. Nice to have a change.
I'm going too quickly. I'm going too quickly.
No, you're not. You're
No,
getting,
no,
you're
you
getting,
can
you're
start
getting,
paragraph.
you're getting it about right, but you just you lost us temporarily.
Authority.
Smetch, yes, I see.
Page 455, 456.
If it is Smetch, it starts at 448.
Yes.
So you're saying 445, which confuses.
I'm sorry. I was going straight to the relevant passage of 455.
455. Got it.
I beg your pardon. And paragraph 28, Mr. Ritchie recognised there are types of cases where the court will be slow to find that a judge made a decision that the decision is wrong, in particular whether findings of fact based on oral evidence and so on. And then the approach which is described as the correct approach is at paragraph 29. Not consider this approach is correct, so recounting the approach
Yeah.
decided by council.
Okay.
Where an appeal is proceed like this one by way of a review of the
Well, why don't we just read it?
Application,
I've already
yes.
read half of it. It seems pretty familiar stuff, even though I've not seen this particular authority. Yes.
The reason for taking you to that is twofold. The fourth line, even where that assessment has been made on the basis of written evidence, which is also
Yeah.
available to this court. So it's important
Yeah.
when considering appeal from a judicial review decision. And the other point is, I'll count lines down. 8 lines down, often a judge.
Yes.
Often
Well, this is so familiar, Mr. Orban. I really don't think you need
I'm
to
grateful.
spell it out for us.
Yes, I'm grateful. I originally was skipping over it, but then thought better of it. The point is factual assessment and evaluation beyond strict findings are within this principle. So that's the overview. And then if I can then deal more quickly with grounds 2, 3, and 4.
Yes.
The guidance, ground 2 guidance, we do maintain the point that the ground was not argued below. There wasn't a challenge on the basis of failure to follow paragraph 3.13. Now, regardless of the way it eventually came up in this court, that is, the appellant is now seeking to run a new point that
Well,
wasn't part of their claim below.
we're normally pretty forgiving about that if it's not outrageous. We're more interested in the substance of the point.
If I can be brief then, we've cited what we think is the relevant test, and that should be paragraph 53 or thereabouts of our skeleton, Singh and Das, and the test is not quite that it's not outrageous, but it is what it is said there. And the point is a relevant one because, in a nutshell, what Singh and Das directs us to is, would the new point involve evidence that wasn't dealt with below? And may the trial be run differently? On this case, this is classically a situation where those things are the case, actually. Because what's being posited is a factual point, a specific factual point that the local authority didn't subjectively have in mind something at the time of making a decision. And it turns on fact. The allegation that the decision maker didn't call to mind a particular paragraph of a document. And if the point had been run below, the local authority could have led evidence on that point and the trial would have gone differently. Would have been handled differently.
The local authority could have led evidence about what?
What regard was had to the guidance, because we do know the guidance was taken into account. There are certainly explicit references in the evidence below to other paragraphs of the guidance. So it's not that they weren't aware that there was this guidance. The issue then is, did they have in mind this paragraph? That's a matter of, there would have been evidence below on. Secondly, beyond specifically this paragraph, did they have regard to the substance of those things in section 3.13? And thirdly, the section 31 Senior Courts Act issue. They're highly likely that there would have been evidence on that if it had been necessary.
Yes, I see.
So the trouble would have gone differently, actually. There would have been evidence, and we don't know how they would have gone. So that's why it's wrong.
Yes, I see.
To deal with it.
No, well, that's one of the cases where we're not so forgiving. So if we're with you on that, then maybe more in the point.
More you yourself before lunch made the point about this paragraph of the guidance 3.13. It seems to be about where the local authority finds the child should not be provided with accommodation. And you were questioning, well, was that the case in this situation in the event? Because there was no decision here, the child, on that section 20 issue. My apologies if I'm mischaracterising a comment you made.
No, just say again what the point is, that whether or not it was my point. What is the point?
The particular issue that we're concerned about with the guidance, section 3.13, is concerns whether the local authority finds the child should not be provided with section 20 accommodation. So question the application of that here, where there was no decision. The local authority was still making its mind up. It was still in that before stage here when called to estimate its offer. It's in our skeleton, paragraph 54, if that helps.
In your skeleton where?
Paragraph 54.
My deafness doesn't only extend to Ms. Hannett. You're not so soft-spoken as hers, but you do speak rather fast.
I beg your pardon.
Okay. Which paragraph did you say?
54.
Thank you.
It was also said against us on this point that what we say on the guidance is inconsistent with the approach we took in High Court, where in the High Court the argument was around on the footing that it may apply. Was there an exception to it, or was a departure from it justified? Well, the way the matter was dealt with in High Court was a function of the claimant's case in the High Court. In the High Court, the guidance was used for this section 175.20 linkage point. And our response was, well, 175 and 20 are not always connected. You ought to ask a question on this issue of the guidance that I hope I've written it down correctly. What if this court decided it would be right to depart from the guidance? So your view was it would be justified to depart from guidance paragraph 3.13, but the decision maker had not subjectively turned their minds to that issue.
Yes.
If positing that hypothetical, if your decision is that it would be right to depart from the guidance, well, in that case, the court would be statutorily obliged to decline relief by virtue of section 31 of the Senior Courts Act.
I just wonder whether there wasn't even a prior point. I mean, in other areas of law, and it's not perhaps analogous, I suppose, but you can certainly, for example, justify a discriminatory practice by reference to considerations that weren't in your mind at the time. But I suppose that's not quite analogous.
Another way of expressing it could be materiality.
Yes, that's really a better way. If it's obvious the answer is X, but you can't identify that they actually thought about it, you just say that's immaterial. You don't need section 31, do you? I think it's one of the points that was made when 31.2a came in.
So we could put it on either basis,
Yeah.
materiality or section 31. In fact, we put in the respondent's notice for that reason. It's in the core bundle, page 70,
Yeah.
where we say exactly what we're talking about now, which is we put in a respondent's notice so we can rely on section 31 if needed on this new ground 2 point. And finally, on ground 2 and the legal approach, there is certainly assertion that it's a legal requirement that it must be subjectively in the mind of the decision maker that they bring to mind the bit of the guidance.
Well, that's what Lord Justice Wilson appears to be saying.
Well, that is not entirely one way. X and Tower Hamlets, tab 25, authorities tab 25. This was the case on not the same issue, clearly. It was about the calculation of fostering allowances and guidance in relation to fostering allowances. But I can make the point very briefly if I take you to paragraph 38, authorities bundle page 420, where the point, my point
So
is...
where tell me where in the bundle is X and Tower Hamlets?
It is tab 25, page 406, starting at page 406.
No.
Page 420, which is Lord Justice Morris K. At the bottom of page 420, you can see paragraph 38. The final and most important question is whether the council has established cogent reasons justifying a departure from statutory guidance. In one sense, any such reasons have a whiff of ex post facto about them, because, as Lewis and LJ pointed out in the course of argument, the council's evidence does not describe a considered decision to depart from the guidance. However, I accept Mr. Rutledge's local authority that a departure from the guidance may be justified by cogent reasons objectively established as such through litigation, even if they were not carefully considered at the time of departure.
Well, that seems instinctively right to me, but how do you reconcile it with what Lord Justice Wilson said, apparently basing himself on something Mr. Justice said, he said, which we weren't referred to and maybe haven't got?
Well,
TG page. Oh, sorry, I did mark it. Page 359 in the bundle. I mean, it may never arise,
yes.
but if it does, what do? Choose the one we think is right?
There are two statements, both from this court, which are not easily reconciled.
I bet you there are more too, you know.
Yes.
This is a very common
Yes.
situation.
So my point,
So on the whole, I think our preference would be not to have to write an essay on it. But
that was where I was headed.
well,
My
right.
point is, it's not one way. It's not as simple as the appellant suggests. And-
Anyway, you say, I mean, like the Vice President, I'm instinctively hostile to pleading point. Your pleading point, such as it is you say that 3.13 doesn't mean what Miss Hannett said. But anyway, if it was terribly important to know what the decision makers had in their minds at the time when all this was going on, then had that point been raised at first instance, you could and would have known evidence about it, and it's unfair to make assumptions against your decision makers, or as Hannett might say, decision non-makers, but anyway, that the people who were running the file for the council. And so maybe, if that's right, this isn't the case on which to write a long essay about whether paragraph 17 of TG and Lambeth represents the law.
Yes, I
There's
do
a
want to
third
spend-
possibility, which I'm not saying is necessarily right. Sorry, I didn't mean to cut my Lord, which is simply that on a true understanding of the guidance, there's no departure from it anyway.
Yes, that was one.
Sorry, well, there you are.
Yes.
Yes. Right, well, there we are.
Yeah.
And I think we have anything more you need to say about the guidance?
To give you a reference, on the materiality point,
Yes.
I think may well be the neatest, the most accurate way to deal with the matter. Our skeleton, paragraph 55, also deals with that. So I'll just leave you the reference. This paragraph, John. 56. Oh, and 56. I'm grateful to remind you. I'll then move off ground 2, unless there are any
Yep.
questions arising. Ground 3, status as homeless or as a trespasser. And the first point we make is to go back to my overview on grounds 2 to 4 and to object to what we see as a judicialisation of a social worker's role or a legalisation of a social worker's role. Social worker's task is to consider whether the young person requires accommodation. And that's rightly based on broad consideration of all the facts. There's a real danger of asserting one matter to the status of mandatory consideration, such as trespasser. It said that the decision is unlawful because status of trespasser is a mandatory relevant consideration. Now, that legalises the social worker's task. It means the social worker has to stop and determine the legal issue of whether the appellant was a trespasser at particular points in time. And they have to get that right. And if they make a mistake on the legal analysis, such as the legal analysis of legal interests in land, equitable interest, or so on, well then they're there on a mandatory consideration and the decision's overturned. And is that really what we think section 20 is about? Requires accommodation. So that first point again is a warning about what can happen to a social worker's role if we adopt this legalistic approach. The issue is whether she required accommodation, having regard to all the facts and the realities on the ground. You don't need to pull out one matter and require reasons of assessment or particular further explanation of one matter on pain of the decision being unlawful. Local authority clearly was aware of the possibility of eviction, the timeline on it, and that was the crucial point. In any event, on this, you make the point in the skeleton, paragraph 59. Which I have had. I beg your pardon. Yes. That within the judgment there is enough to cover, to make good a section 31 point on this if needed. And that's from the judgment below, the paragraph 119, and the finding expressed there, which has been taken to and it's the bundle page 137, at the bottom of 137, last 4 lines. I judged that the defendant had considered that there was 175 homelessness, which Mr. Sheldon submitted would mean the test was technically met, along with the fact of trespass, it would have made no material difference to the decision. Over the page, highly likely the outcome foresee would not have been substantially different. That is repeating the words of section 31. The only thing missing is section 31 Civil Courts Act. Willen Jr. makes a further point to me that to make good this ground, we will also have to show that we were rationally required to make that decision within the 5 days going to the 18th birthday. The last ground, now issue ground 4, irrationality, I will, as expeditiously as possible, try to do 4 things. 1, summarise the key points on this ground. 2, direct you to factual findings which bear on the irrationality ground. 3, deal in some manageable way with the underlying evidence and factual chronology, bearing in mind the time. And 4th, to look briefly at the issue of eviction risk and timing. The first point, a summary of our key points on irrationality, that's in our skeleton paragraph 61, which has 5 circumstances why the decision is rational: living in the flat, breaking months of people living there, the local authority accommodation under section 20 would not have been, could not be accommodation with her boyfriend, which is what she wanted. She was in a place which she had access to children's services and social work support. She wasn't under an immediate threat of eviction, and Colchester had made clear that it regarded itself as requiring court order, which, as we know, impact on the timing of eviction. The point being that Essex rightly looks as to whether she requires accommodation for the time that section 20 applies. Section 20 has application up until her 18th birthday. So that's why timing is relevant. And lastly, that she's able to stay in the present home for the time that section 20 was capable of applying to her. And Colchester weren't taking steps to enforce in that time scale. We knew that. That's the overview.
It's not just until she gets to 18 and then we can wash our hands of her. It's until she gets to 18 when they can give her a tenancy.
Yeah, yes.
Yeah.
Yes. And there obviously was communication with Colchester through that. But the point of focus is section 20, does she require accommodation? What does that mean? Does she require accommodation in the time section 20 applies? Not does she require accommodation for the next 5 years. Which is why time is relevant to rationality. The second point is that there were factual findings on this very issue. And I can do this largely by giving you references to the judgment. I'll give you paragraph references to the judgment, if that's okay, rather than page references. Paragraphs of the judgment below. Paragraph 18, overwhelmingly likely outcome is precisely what occurred.
So sorry, you're going rather fast. Judgment, which paragraph?
18.
Yes.
At the end, might take around 12 months for the hearing of any possession claim.
I don't suppose you have done the exercise of having the page references to the bundle for that. We can find it, but it's just
107, 108.
Sorry.
107, 108.
Of the hearing.
No,
bundle.
sorry, no. I'm sorry, I don't.
Junior might have done.
For the judgment.
No, for I think
The letter of the 7th of February being referred to in this paragraph, where is it in the hearing?
I can find that. Yes, in another
Yeah,
document.
actually, it's one of the ones we referred to.
158.
Sorry?
158.
Thank you. Is that right? Seems unlikely.
It does, doesn't it?
Because all the key documents are in the sort of 300.
Yes.
Look, don't spend time doing it now.
No.
If there'll be brownie points for anyone who, as we are referred to a document, can tell us where it is in the and of course I'm wrong. It is 158.
There you go. I'll continue on with judgment references, and if you don't mind, I'm sure if anyone, including the junior, shouts out a final reference, all the better. Judgment, paragraph 20, quotes the internal note from Colchester. We do not want to pursue mandatory possession, as this will take a minimum of 12 months. Again, timing is relevant to rationality. Judgment, paragraph 104, was
So you're going from judgment power 20 to judgment 104.
yes, an important finding.
Hang on 1 second.
And 104 is related to the bundle. Or to the-
One,
not related to the
paragraph
judgment, is it?
104 of the judgment, which is
It was appropriate for the defendant to seek to rebuild the claimant's relationship.
yes.
Right.
Got it.
Judgment paragraph, that's the High Court judgment, paragraph 109. On the bundle, page number, it's 135. Again, quoting from correspondence on the likely time scale.
That's 155 below.
Thank you. And then Junior gives me the reference of paragraph 155 of the High Court bundle.
Page.
Page 155 of the bundle. Thank you.
Yeah, I've read that.
The next paragraph of the judgment, which is judgment paragraph 110, you can see the last 3 lines for her part. C made it clear at various points, but consistently she wished to state the property. Again, we said it's a factual finding which is relevant to this issue of irrationality. Paragraph 119, or bundle page 137, is a document, is a paragraph we've looked at before. 8 lines down, we have the sense of realism point we've seen before, and then the notion that a body like CBH, Colchester, which itself repeatedly expressed concerns about C's position, would take civil action against a child is fanciful. Again, that's a factual finding, we say bears on the issue of.
When you say civil action, that's about proceeding against FME profits. It's not about eviction. Oh right,
I maybe
everybody
read
except
it,
me
but
thought it was about eviction.
If you look, like, if you look just before that, C was in principle at risk of being sued for trespass and exposed to risk of damages. So
Yeah.
it seems to be both.
Well, if you're sued for trespass, damages are what comes out of it.
Well,
This is not. I don't think this is referring to possession action. I think.
I'll leave you with that.
Okay.
And also the judgment over the page, paragraph 120 onwards, dealing with other various aspects of the housing circumstance, the door, the support, and so on. And these are findings which bear on rationality, findings made in judgment below bear on rationality. Overall, decisions made based on realities on the ground, which make a rationality argument, we say, untenable. The third point on rationality, the underlying factual situation. Now, I could take you right through bundle, or actually I was going to go by the chronology that may take about an hour, but I don't think it's necessary to take you to each of the references in chronology because I think you probably read it more than once.
We've certainly got a good picture of the engagement between the council and the claimant, out of which the social workers, I speak for myself, seem to come rather well.
What I'll give you the points I take from it, which I say are evidenced in that chronology and the underlying documents. And if I can give you that list, and then if you're not satisfied of any, then I can try to show you where they are. But the things
Sorry, I
think-
should have said that observation. I was making an observation not related to any of the issues in the case. I merely, I didn't want Ms. Hannett immediately to get alarmed. They could have been doing rather well and still got the law wrong.
Yes.
So, but they clearly engaged with her conscientiously.
The things we think you see from the chronology and the source documents underlying them are 7 things. I'll just give you the list and see if that's sufficient. 1, that the social worker's decision, or rather their approach to the issue of the appellant's accommodation, was a nuanced and complex one. The second point is that the level of housing security or insecurity was certainly at the centre of the social worker's considerations. It wasn't if it was, it's not as if it was missed or not known or overlooked. The third point is that a formal legal characterisation of that situation, whether you call it trespasser or having a licence or whatever, was part of that overall picture. The fourth point is that there were very significant reasons to stay put for the time being.
Very what reasons?
Very significant
Yeah.
reasons to stay put for the time being. We know her home, where she'd been, her wishes, boyfriend, cats, and so on. Fifthly, social workers working on the issue were working with the appellant to look into alternatives. Initially,
Working with the appellant to do what?
to consider alternatives, to
Gotcha.
investigate and consider alternatives. You will have seen the initial period, there were a lot of references to MF, the mother's fiance, the mother's partner. So at one point, the mother's partner was living there, and that was considered. Would that be appropriate, or how would that work? Another
Sorry,
time,
am I just missing the fact? You say mother's partner, it's the father, isn't it? No, not the father.
fiancé.
Sorry.
MF, in the notes, it's MF.
So sorry.
MF.
He was living there at the beginning.
He was
and
living
then
there at the
moved out.
beginning.
Yes, I'm so sorry. Yeah.
The father had separate consideration. At some times, the social worker was seeing if reconciliation was possible. Then
Sorry,
other
yes,
times
yes.
it wasn't possible.
MF is mother's fiance.
Fiance, thank you. At other times, there's discussion about the boyfriend's parents. That came in and out of consideration. My point is, social workers looking into these things with the appellant and working on consideration of them. Sixthly, and the penultimate point, as for housing, the appellant was not actually at realistic risk of being put out of her home in the time that Section 20 could apply in relation to her. Because Colchester considered that they would need to go to court for an order. Whether rightly or wrongly, it doesn't matter. We're dealing with a factual reality. And the final point, seventh and final point, Section 20 was still being considered at the time Colchester made its offer.
At the time of
Colchester made its
Yeah.
offer. the meetings before that offer were discussion of Section 20 options, wanting to think about it. So
This is when she's given that table.
17th of Feb.
thank you. The final point I was going to cover, I'm not sure if it's necessary, is the risk, eviction risk and timing. But I think we pretty much covered it. If I just leave it right back. Yes, it's in our skeleton, paragraph 63, 64 to 66. I don't see the need to repeat it. So then, by way of conclusion, two points. One, to touch on a point Lady Justice King made early in the morning, which is that I've written it down as stepping back on this issue. The purpose overall of the 13-week period is that leaving care provisions are designed for those in care. But here, that's not really what the appellant wanted. She didn't want to be in care at all. Or at least she was, at minimum, and putting it most neutrally, she was still considering the Section 20 options at the point Colchester made the offer. So it's quite wrong to think of this as a natural case, the application of Section 20. It's far from it. And linked to that, well, it doesn't mean that social services are out of the picture, both before and after 18th birthday. The question was asked, well, would she be eligible for adult social care after 18th birthday? Well, she may well be. She may well be. It depends on a Care Act assessment. There would need to be an assessment of her needs. She may well
Sorry, may well be what?
eligible for adult social care after her 18th birthday. It's dependent on assessment. And the final point is to note issues of relief if you find against us on any of the grounds 1 to 4. We find out this morning that the appellant is not pursuing ground 5. And the consequence of that is they're no longer challenging local authority's decision on not treating the appellant as a former relevant child. So, given that's no longer pursued, it's not challenged that we decided not to treat as a former relevant child.
I mean, otherwise, then they're remedially for a previous breach.
Yes.
Yeah. Okay.
Even if you now find against us on grounds 1 or 2 or 3 or 4, or any one or more of those grounds, it's difficult to see how the appellant would resist the application of Section 31 or any other description of whether it's materiality or anything else. Because the issue she wants is to be treated as a former relevant child and have the living care duties applied to her. But she's no longer challenging that decision. And it's difficult to see how, say, ground 2 got up. That would have a realistic prospect.
Hang on, is that right? This is how I thought the overall way of the case went. If there was an unlawful decision not to treat you as Section 20 as applying before her 18th birthday, then we are in GE Eritrea territory. And it would be open to the court to require you to treat her as if she had been given accommodation under Section 20. Now, you may or may not want to say anything about that chain of reasoning, but that's not affected by her. All that they've abandoned by ground 5, as I understand it, but I may have got this wrong, is the suggestion that even apart from what in that GE Eritrea route, there was a residual discretion on you to treat her as a former relevant child.
Oh, well, just for clarity, that's absolutely correct.
Well, that's
So
what I
friend can
understood.
address that.
Yes. Well,
In which case, if that's right, I think the point you're making now isn't right.
well, there are two issues. One, the sole outcome, which is if we made an error, is the sole outcome that we would treat her as it should be treated as a former relevant child. And for that requires the very high test that's mentioned of read off the bit, a very high level of egregious breach. And in this case, on any proper analysis, is nowhere near that level of alleged wrongdoing. So the only issue then is on the residual, or what's said to be residual discretion. You have to, obviously, it depends on if you
Oh, hang
found
on, sorry.
against us.
Are we at cross purposes? She's abandoned the residual discretion point.
I beg your pardon. Beg your pardon. So, if it's a matter then of the sole justifiable outcome, we say whatever you may decide against us on grounds 1, 2, 3, or 4, it's nowhere near that level of egregious error or egregious breach. If I can speak in a term like that.
Okay.
Those are my submissions. Thank you.
Thank you very much indeed, Mr. Orban.
Well, I'm just going to take that last point first. I do have a few short points in reply, but just as we're dealing with that, maybe sensible. We put our case below and we maintain it here, that if we're right or an error of law, then the sole justifiable outcome is that there ought to be a mandatory order requiring the local authority to treat DF as if she's a former relevant child. In the alternative, there ought to be a mandatory order requiring them to reconsider. But of course, those are matters, if I may suggest, that are better probably determined if I succeed on any of my points, and depending on how I succeed on my points.
Yeah.
Those are probably matters best left, if the court agrees, with submissions in due course, rather than trying to explain which one we say fall in and we fall in and why now, without the benefit of any judgment of the court. So that's that last point. Just briefly, a few points, if I may. I'm very conscious of the time, and I will try to get through these in 5 or 6 minutes. I'll try not to go too fast, and I'll try to speak very loud.
I don't know why you've fastened on 5 or 6 minutes. That are clearly more economical, the better. But I'm not saying you have to sit
I
down.
thought you were only going to sit until 4, so I thought I was trespassing beyond.
No.
Well, I won't be more relaxed, but I'll be a little more
Don't-
relaxed,
don't-
if I
but,
may.
it's important. It's an important case, and take whatever time you need. Having said that, it's only a reply, and Mr. Orban has been economical.
Yes. So I just want to start, if I may, with section 20 and this point about when the section 20 duty crystallises. My lady, I come back to the submission that I made this morning, that it is a conditional duty. And in support of, perhaps if we could just turn up to section 20 so that we've got it in front of us. It's on page 25 to 26 of the Bundles of Authority. And it is, of course, a duty to provide accommodation, but if that duty to provide accommodation has arisen and no accommodation has been provided, there may still be a breach of the duty. And indeed, when one looks at subsection 6, so that before providing accommodation under this section, the local authority shall, so far as is reasonably practical and consistent. So it is a shall duty, but it's not. There are circumstances in which it may not be reasonably practical or consistent, and that's no doubt, of course, because in some circumstances the duty to provide accommodation will be very urgent and must arise contemporaneously with the child.
Well, all that's true, but isn't there force in Mr. Orban's point that subsection 6 is only workable except in ignoring cases of extreme urgency, if there is a process which starts with a recognition that they may require accommodation, but you've got to ask them first.
Well, it's also, it's better read in my submission by understanding it as the duty to accommodate has arisen, and whether or not that duty should be discharged and how that duty shall be discharged. So, for example, by reference by what form of accommodation, section 22C, those are the kinds of matters that the local authority shall, so far as reasonably practical, etc., ascertain the child's wishes and feelings. Because, again, this is an area in which, of course, vulnerable children and so on and so forth, and the difficulty with construing it in the way that my learned friend invites you to is that there could be quite a long delay between a child presenting as requiring accommodation and those kinds of discussions.
But that's where the
exactly what
constraint of
happened here.
practicability, which you've rightly drawn our attention to, would make sure that the child wasn't put at risk while you were trying to find out what they thought.
But for example, in this case, on our account, the duty arose on the 4th of 2nd or so January. There were no discussions or no offers or proposals given to the claimant until the 27th of February, several months later. And in those circumstances, in my submission, that potentially significantly undermines the protective aspect of section 20, which must ultimately to be ensure that children who require accommodation are provided with it and quickly. Now, that doesn't, in my submission, none of those points undermine the construction that posited this morning, that the duty arises how it is to be discharged, and indeed whether it is to be discharged, are matters that have to be discussed so far as is reasonably practical, etc., with the child or young person. And that in my submission, section 26 must apply just as much to a 10-year-old as it applies to 16 or 17-year-old. Of course, the weight that the local authority place on the wishes and feelings and so on and forth will be different. But the point is that it must apply across all ages of children, not just for 16 or 17-year-olds.
At what point, I mean, that's no doubt true in principle, but so what?
Well, it means that the provision, the duty crystallising shouldn't be delayed or held up by the need to consider the wishes and feelings of the child. That's the simple point. My Lady Justice King made a reference in discussion with my learned friend about that the claimant was expressing her wishes and she wasn't making reference to foster care. Of course, that's not the only way that Section 20 duties can be discharged. I've shown you very briefly.
And you're
Yes.
saying you should have somehow squeezed it into other arrangements, even though she wasn't asking for any of those. She wanted a flat
Well,
on her back.
the difficulty, Melody, here is that no offer was in fact, no discussions of types of accommodation were had with the claimant until the 27th of February. So none of those options were put to her. The judge makes a finding of fact that she didn't refuse to consent to any of them. That's not appealed. So in the circumstances that she didn't.
Note of realism?
Well, but Melody, if we're right, and the Section 20 duty arose, I've taken you to this afternoon to the note where she's asking for assistance with housing.
But she's asking for.
Asking for assistance with housing, and she's asking for help. So it's quite clear that she's trying to find some accommodation, and yet no offers are made until February. As I'm saying, that looking at it with hindsight, of course, Colchester did come riding to the rescue in the middle of February, but the position in January was that those offers hadn't been made. Can I also just respond also to the point about the DS boyfriend? It said that we didn't appeal against the judge's finding on that. In fact, we did appeal against the judgment's finding on that. That's ground 6. The respondent replied by way of their response to the appeal. I'll just show you that. It's core bundle, page 52. Paragraph 11, where they make the submission that ground 6 is academic. And the question whether, if ECC had reached the opposite conclusion, it could lawfully have withheld a particular type of accommodation is academic. In other words, because that reason wasn't because they never decided that she was over duty, whether or not it could be discharged by providing accommodation with a boyfriend as academic, that was an argument that was accepted by the judge on the grant of permission. So it's with respect, a little unfair now for my learned friend to resurrect that argument in circumstances where we did try to run it. They suggested it was academic.
Sorry, I've got lost. What is the point you're worried about?
Suggested that there's a finding of fact made below that the local authority had made a lawful decision that it wasn't appropriate for DF to live with her adult boyfriend, who was just an adult, just over the age of 18. We did endeavour to appeal that finding. We applied for permission to appeal. The response to that was that the point was academic. In other words, it didn't go to any of the issues.
I haven't understood why all this matters. What big point does it go to?
I'm so sorry. Taking a step back,
Yes.
The big point it goes to is there have been a number of submissions that DF didn't want Section 20 accommodation, or that the accommodation that was going to be offered was contrary to her own wishes and feelings. And I'm attempting to deal with those submissions, both in respect of the boyfriend, but also in respect of the accommodation that was ultimately offered to her. And that it's that none of that, first of all, that accommodation was not offered until late February. And second, in respect of the boyfriend point, we did try to appeal that finding, and for the reasons I've just given, permission wasn't granted. There was then a series of submissions made to you about the 2002 order and the way that it fits with the homelessness legislation. And the difficulty with the submission of my other friend in that, on that particular point, that they presupposed that our case was that all that one can't. Sorry, let me start the submission again. That that you can't be a homeless child, and any homeless child necessarily requires Section 20 accommodation. That wasn't our submission. It was any homeless child requires accommodation. So the points that were made in my submission don't assist you in that regard, because they don't actually engage with the point that we were making, which was not as wide as my learned friend was putting it to you. There were then a series of submissions made to you about the nature of the decision making and how social workers reach their view. I do advise a degree of caution in respect of that. The social workers here did, as they're required to do, undertake a child in need assessment, and they did produce a child in need plan. That's what they're required to do. And those are decisions that are susceptible to challenge under judicial review. There isn't some immunity of social work decision making. And in my submission, it would be unfortunate if there was any suggestion that approaches to social work decision making are, for example, not required to follow statutory guidance in the same way as the decision makers and so on, the way that I suggest. In respect of ground 3, you were taken to Tower Hamlets. Well, can I just invite you to read in due course paragraph 39, which makes it...
I haven't read it in due course, let's read it now.
So, sorry, I made a note of the... It's a short point, it's just that 38, the bit my other friend took you to, 39.
You're ahead of us. Is this tab 25?
So sorry, yes, tab 25, page 421. So I'm looking at 39, which is immediately following on from the passage my learned friend took you to. And it's apparent from that paragraph that the judge, the court finds in effect that the judge below didn't reach a wrong conclusion about the absence of cogent reasons. So, in other words, the analysis in the previous paragraph is not strictly necessary for the decision.
So we've allowed Ryan Wilson.
Indeed. And then to ground 4, we're taken to a series of factual findings in the judgment at paragraph 80, 20, 104, and those were all matters that occurred in February 2023, so we say after the time it's relevant. There was a reference to the relationship with the father, but we say if one looks at the child in need plan by the 7th of December 2022, core bundle to 41, there's no suggestion at that point that accommodation with the father was appropriate. So by December, that option has been dispatched. There were then 7 points that my learned friend took you to. And I don't intend to deal with, I just intend to deal with one, and that is that, again, that there were a number of options that were being considered by Kent and then rejected. But again, if one goes to the child in need plan by December, those options really had been ruled out by that point. So we say that by the end of December, the beginning of January, the ground was clear. It's apparent that Colchester would evict, and that the other options that had been in the mix at various points were no longer there. Finally, my learned friend made a point about adult social care. We don't accept that. Of course, if there had been a advance below, we would have produced evidence to explain why that was simply not the case. A little bit late in the day to be doing that now, but we invite you to reject that as a possibility to the extent that it goes to anything in the case. May I just turn
To
my
be fair,
back?
I think the availability of adult social care, though, it's naturally something we're interested in because this is a human story. It's not really relevant to the issue of law.
I understand that.
But I forget
I
what
don't
you
think it
phrased
can
it.
be
It's probably
assumed that
been-
it's a solution to any of DF's ongoing issues. May I just turn my back? I can help you further. Those are the reply submissions on behalf of DF.
Thank you very much. We will be reserving our decision. We're aware the case was, to a limited extent, expedited because obviously, if there is a chance of, if the appeal succeeds, there's only a time-limited window which will really benefit. So we will bear that in mind. I'm afraid that doesn't mean you will get it very quickly because we will have other commitments, but we will give it such priority as we can. We will follow the usual procedure in circulating copies of the judgment in draft so that the parties can make submissions on any consequential matters, or preferably agree them, and also draw our attention to any typographical or other errors. You will be aware that effectively those are the only purposes for which the draft is circulated, and that restricts the number of people to whom it's proper to send it, and you could get into serious trouble if you are casual about that. Thank you all very much.